Recording in progress. Recording stopped.
One car, why can't I hear anything myself? Am I the only one who can't find any sound?
Mthembu omkhulu kusathe cwaka.
Mvelase
Hayi, ndiyabulela.
angeke ube nguwe wedwa abathembu bebaninzi kangaka.
Ndiyabulela, Thembu omkhulu.
Kuyaphileka Mvelase?
Ndiyaphileka noko, kodwa khona nawe?
Siyaphila nathi akabikho. Kondomse na uvuke kakuhle?
Kakuhle kakhulu Chair.
Ewe ma.
Sisacenga kwintsana.
Ya.
Ninjani na?
Hayi chunazo. Akho khalaza. Sisazama noko uba siqokelele inkomo zobawo.
Injalo. Inkosi tata.
Enkosi. Manyamzane iphelile.
Kuyaphila mampondomise, ndivile.
Manyamza.
Andikamboni Chair apha eplatformini.
Oh, akakho. Mamkakaza niphelile.
Philile tata Khonto, ninjani nahlala?
Siyaphila nathi akabikho. Any apologies?
Yes, Chair, I've got 2 apologies from Minister no DM Chapa. They want to be excused around about 10:15 to attend to a committee cabinet meeting.
Enkosi. Honorable members, any apologies?
Chair, GM Squatcha here.
Again,
I also sent a similar apology. I'm not sure why it has not reached the secretary, but I also have a similar apology. SPCHG will be sitting. Thank you, Chair.
Siyabulela, DM. Any further apologies, honorable members?
My apology, Chair. I did receive the one for DM Squatcher as well. Sorry, Chair.
Enkosi. Thank you, honorable members. Allow me to greet you all this morning. Molweni kubahlali, dumelang bakhaetso. Good morning, goeiemorgen, on this wonderful morning as we gather in our virtual meeting on the Portfolio Committee on Agriculture, Land Reform and Rural Development. Honorable members, we gather today as whispers of a temporary ceasefire in Gaza and all over occupied Palestine are in the air to allow inter alia for exchange of hostages. This is as we enter the 46th day of the current wave of ethnic cleansing genocide in which more than 13,000 Palestinians have been killed and more than 32,000 have been injured, being 75% of whom are innocent women and children. Yesterday, we honored the children of Gaza and occupied Palestine since it was the World Children's Day. We want to take this opportunity, honorable members, to salute the collective Palestinian solidarity protest actions in South Africa, in the SADC region, and the African continent, and the entire global community that has resulted in the efforts, particularly here at home, where we have witnessed the recalling of the apartheid Israeli ambassador back to his Zionist state. Honorable members, I cite these developments because land is central to our deliberation today. The apartheid Israeli occupation has denied Palestinians their right to their own land after 75 years of occupation, and instead pursues a systematic genocide, ethnic cleansing, and crimes against humanity. In the context of the PDAL bill, we applaud our government for pursuing progressive legislation that not only deals with the effects of dispossession, but also the historic ownership of land and what is best in ensuring the long-term sustainability, protection, and viability of agricultural land in South Africa. Today, we shall be considering the submission from the National House of Traditional Leaders and Khoi-San leaders. Honorable members, we recall that the committee wrote to the National House of Traditional Leaders and Khoi-San leaders, inviting them to make an input on the preservation and development of agricultural land bill. The National House has responded to the request and sent its submission on the PDAL bill, which has been circulated to us as well as to parliamentary and state legal teams. Parliament has a duty to consider all public and other inputs on legislation, and therefore, honorable members, we will today deliberate on the submission that we have received from the National House of Traditional Leaders and the submission that we received from the Minister of Forestry, Fisheries and Environment, which may also receive inputs from the legal team and the department on both the submissions that we have received thus far. We will be continuing, honorable members, to also consider the A list that has been circulated to ensure that it has captured all the committee's inputs, including additional amendments on which the department has made concessions on, which were not included in the draft A list as discussed in the last meeting. If there are any inputs from the submissions on the National House of Traditional Khoi-San leaders or the Minister of Forestry, Fisheries and Environment, that the committee is of the view that they should be effected into the PDAL bill, legal services should assist and advise on how these can be included in the bill. Honorable members, we should therefore deliberate and reach consensus on each amendment, and the parliamentary legal services may advise on how the final clause will read after capturing the amendments. Honorable members, the Parliament legal advisors will develop the A list as I've alluded to earlier and incorporate the amendments into the A list for consideration. I have, without fail, on numerous occasions, drawn attention to this process of developing legislation, and that we should not take it for granted as the majority of our people were denied this fundamental right. May South Africans never and never and never again be deprived of the right to participate in processes that affect them, nor of the right to own and preserve land for posterity. Allow me, therefore, honorable members, to request the presentation on the submission made by the National House of Traditional Leaders. There's the presentation, the Honorable Minister, Mamu Togo Titiza, Siyabulisa. Is it your presentation or presentation of the officials? Ntate Serage, are you delegating upwards or downwards?
Honorable Chairperson, good morning and good morning to members and Minister and my deputy ministers. I was waiting for them to delegate, Honorable Chair, so practically the presentation.
Okay. Mamutideza. Uyasibambezela. Mamutideza. Usekhona?
Akakabonakali Chair eplatformini.
Akabonakali. Uba usikhwatsha?
Ukhona.
Ukhona
Any
yena.
opening remarks and can we proceed?
Thank you very much, Chairperson. I would want to suggest that we proceed and give over to the acting DG if he's present in the platform. If not, Ntate Serage may proceed with your permission, Chair.
Thank you, DM Squatcher.
Thank you very much, honorable members, and thank you very much, Deputy Minister Squatcher, and greetings to honorable members and greetings to Director General on this call. I know he is challenged with a voice, but he's here. And also to the parliamentary support staff, legal and other support. We are presenting before this August committee our responses to the written submissions that were received by the committee from the National House of Traditional and Khoi-San leaders, as well as from the Department of Forestry, Fisheries and Environment. We have grouped them together, Honorable Chairperson and Honorable Members, because they seem to be the same in approach. If you just want to quickly get the system to work quickly as I go to the next. Perfect. So acronyms are the same acronyms that we used previously, and nothing changes. The purpose obviously is to respond, like I mentioned, to the written submissions, which we went through and thoroughly and assessed what we thought of them as being the intention, hence our following responses. According to them, it is their view that the minister can have powers over agricultural land, except for the 13% of the land that is under the hands of traditional or tribal authorities. And we note the comment, honorable members, but we want to emphasize, like we've done before, that the intentions and the object of PDAL is nothing new from what Salah did as far as the ownership of land is concerned. The intentions and the purpose of PDAL is to preserve high-value agricultural land and to ensure that any land in the country is so demarcated and set aside for so that the country can be able to produce food and fiber and fodder for the country. So it does not take away anything. As things currently stand, as far as matters traditional authorities and leadership and municipalities and provinces, the law still applies that land is the use of such land is under the authority of the subdivision of agricultural land. So this does not change at all, except that whoever owns land will continue to own land, except that if such land has got a high value or is considered a high value agricultural land, that land can only be used for agricultural purposes. That's what PDAL seeks to achieve. The same where they wish that the continuation of that, where they wish that it be preserved and controlled by the tribal authorities and their communities. Again, Honorable Chairperson and Honorable Members, we do not dispute that the land will be under the administration in terms of other laws of our country, but we further continue to reiterate that the only angle that new angle that PDAL brings in is to be able to map up, to be able to identify, to be able to assess and set aside land that is considered to be of high value, land that produces more food, that such land must not be used for anything else other than agricultural purposes. So whoever owns land, whoever controls land, whether the land belongs to the municipality or the
Recording in progress.
or the provincial department, the land with the ownership will remain the same. The use of food security in the bill did not consider the actual scenarios of household food security in many communities, such as community food service initiatives that were started by women in their backyard gardens, child-headed households, and unemployed youth in communities. This is addressed, honorable members, under clause 4, subclause 1, paragraph F. It addresses the balanced participation of all agricultural land users. And it really would not change. Perhaps here the National House of Traditional and the Khoi leadership might have misunderstood what the clause seeks to achieve. But the preservation and development of agricultural land is to ensure that all forms of food security initiatives by anyone, including child-headed households, including unemployed youth, and including any person who participates in the food production value chain, that is still protected and will not change for as long as that which will be happening on that land is as we are going to, as the Act proposes, that it will be registered and classified as such. So if that land on which child-headed households and on which traditional authorities, provincial departments, and any other land owner, if the activities are towards the food production, that will not change in terms of the object of this bill. The other comment is that this clause reduces ownership rights over agricultural land. So they think it means that South Africans will not have individual ownership of agricultural land. Therefore, even if expropriation of land without compensation is avoided, the National House of Traditional and Khoi-San leadership thinks that the bill will reduce significantly the normal competencies of ownership of agricultural land. And we again emphasize, Honorable Chairperson, Honorable Members, that clause 1 in line 15, it relates specifically to land with the object to promote preservation and sustainable development of agricultural land. Sustainable development in this case would mean, much as the land shall have been demarcated as per the intention of this bill, much as the agricultural land shall have been identified, mapped, and zoned, that land, a production of food on that land will have to follow all the normal sustainable agricultural production intentions and processes to ensure that in us producing food, we do not do that and pose danger, if you like, or we do not do that at the expense of the very land that is supposed to be preserved for food production purposes. Further comment is that agricultural land evaluation classification, which we have at clause 5, subclause 1, paragraph A, that it empowers the minister to establish evaluation and classification system to apprise, amongst others, the potential use of agricultural land. The House feels that there are no restraining criteria imposed on minister except the duty to consult with provincial counterparts. And it does seem that the National House of Traditional Leadership and Khoi-San leadership feel that there ought to be some constraints so that minister does not have overarching and infinite powers. We noted the comment, but if we look at clause 5, and if we were to read the entire clause 5, they would have noticed that agricultural land and evaluation and classification will be based on the inherent capability of the natural agricultural resources, which is based on a scientific process. So in matter science, it is not arbitrary and it's not up to the discretion. It will rather be as provided for or as aided by science. So it's not like the department will just one day start a process and classify land that is not considered high value to be high value. There would have to be scientific analysis and scientific justification for such land to be declared high value agricultural land. The provision should be amended to include a duty on the part of the minister to also consult with affected land owners, traditional council, whose land fall within the contemplated area, Clause 5, again, it empowers the minister to fulfill constitutional functional areas of agriculture. So in this specific case, consultation, in fact, the entire PDAL, honorable members, is really stems on a thorough consultation. It stems on establishment of structures that will enhance continuation, coordination, that will enhance a thorough consultation and until a decision is finally made. So we think if the House had gone thoroughly through the clause, they would have picked this up, honorable members, but we stand ready to engage again if needs be to show and assure the House that the intention of this bill does not take anything away from what they already have. Instead, it just ensures that the agricultural land is used and is not turned into anything else other than land on which South Africa will produce food for its citizens. The declaration of the protected agricultural areas, this also is one of the key elements that are brought into law that with the intention of this bill intends to bring into the law of the country. So they're saying clause 11 sub clause 2 of the bill provides that minister may declare a protected agricultural area to protect land capable of producing significantly high levels of agricultural goods. And yes, it's true that the description of land capable of producing high level of agricultural goods as described at clause 11, 2 subclause 2, paragraph A, subparagraph 1 to 5, where it entails that a land capable of producing higher output due to a combination of favorable conditions such as climate, soil, the locality, those will be the criteria used by the department to classify or to declare a protected agricultural area. So this again does not bring anything new. They won't be. It's not like where there was houses. If I use an example, the department will come and say change the houses into the area where you have houses, change that such into an agricultural land. That is not the intention of the bill. But the intention of the bill is to say where the land is being used for agricultural purposes is to basically to prevent further change if such land has been declared. And also the intention of the bill is to ensure that land in private ownership is not changed for anything else, even if it changes hands. Even if the land that is in private ownership gets sold, it should be sold for the next buyer or purchaser should only use the land for agricultural purposes. That's what this means in essence. They say the provision does not indicate higher than what, basically the qualification of higher. And again, we say, if they had read the clause 11 in its entirety, they would have noticed that we qualify the higher on all the subparagraphs are explaining what that would entail. But this in the main is about the landscape or the land that is capable of producing high agricultural production. So in a land that, or maybe the question should be, how do we then arrive at a land that is considered to be of high value agricultural land? And science assisting in science enabling and science dictating, it will be the procedure to be followed would be those mentioned. This would include the type of soil that is there, the climate, the terrain, and other environmental factors that are within that microclimate. So agricultural zone that is there will dictate whether such land is declared to be of high value. So high value, as we know, for land to be of high value or for land to be able to produce food, the difference is in those factors: soil type, climate, a lot of other conditions that affect affect agricultural production. So in other words, if a land, it could be for a naked eye, it could look beautiful land. It could look like the land is very nice. It's not a slope, it's flat, but the conditions, climatic conditions, soil type, and a lot of other factors that are taken into account when production is made it could be that those are not fireable. So such land might not be classified to be a high-value agricultural land. I just wanted to bring the contrast and the backward approach so that members can appreciate that the intention really is to allow science to dictate lawmaking in the country, is to allow science to help us be able to preserve the current land that we have, that most of it is under private land, private ownership, for it to be continued to be used for food production and agricultural production, for it not to be changed into anything else. They say, the House says this will infringe landowners and traditional councils' land, whose land falls within the contemplated area. Again, we say it will not infringe in any way. The procedure that will be followed before a declaration is made is clearly defined under Clause 12. And it entails, like we said, a thorough process of consultation, engagements, and scientific evidence. So it's not going to be arbitrary. And at the same time, it will not infringe on the ownership of the land, the rights of whether the real rights or perceived rights. Such would not necessarily be infringed upon because the science and the process would allow for representation, would allow for engagement and thorough engagement. And on the basis of evidence, the declaration will then take place. Clause 5, subclause 1, paragraph A gives unrestrained powers. Again, this is the talk of where the House feels that the minister has unrestrained powers. We've explained there that they're not unrestrained because, one, the powers of the minister are subject to or are subordinate to the laws of the country, and the powers of the minister are subject to any other provisions of the legal provisions in the country, as well as those conditions of under Clause 12 and 11, which are about consultation, thorough consultation, and structures that would have been formed. So this we responded to already. Same with this comment was responded to in the same way. This basically the House is emphasizing on what they perceive to be unrestricted powers of minister, but we can assure the House and assure the members and everybody else and the public that the powers are not unrestricted because they are still subordinate to the laws of the country, but at the same time, there will be a thorough consultation, which is provided for in the bill. So the reasons why this was provided for is that was a vision and also forward planning to, in anticipation of a process where a consultation will have to be thorough in order for the process to be transparent and open, so that whoever is impacted upon will have fair chance and ample opportunity to make representation. But we don't foresee many representations in this specific case, because the land that we're targeting to register and to protect and to classify is land that is currently under agricultural production. All we are doing is to prevent any further change of such land into anything else. Procedures to declare protected agricultural area. Again, this we explained that prior to any declaration of agricultural or a protected agricultural area, there has to be a process of consultation with all affected parties, starting with the landowner, all the leadership in the hierarchy, in the order. Everybody else affected will have an opportunity to make representation, and there would already be structures established. And finally, science will dictate whether such land is indeed qualifying to be declared a high-value agricultural land. It is the submission of the House that traditional councils and landowners whose land falls within the contemplated area must also be consulted when a protected agricultural area is declared. We agree 100%. They will be consulted, and it's not a discretionary consultation. It is provided for in the bill. Again, agro-ecosystem authorization, the comment that it introduces a system where agriculturalists and private landowners would need authorization before they may do certain things on their land. The House seems to prefer to have the owners of land decide on what happens on their land, and especially when they need to go to have other authorization for other activities on that land. We do not agree with their view, and it is in any case for land that is under the ownership of traditional council, provincial, and national government. For anything at the moment with the current Subdivision of Agricultural Land Act of 1970, that still covers that. They do not have that. They cannot go ahead and embark upon any ecosystem processes without the authorization in terms of the subdivision of agricultural land. So this area is not new; it's already regulated by government. So it's not really new. Perhaps the House was not aware of the fact that even without PDAL, this area is still regulated. They again further said that clause 16.2 that the minister must be convinced that this activity should be capable of having a permanent negative impact. Of course, like we responded to earlier in the earlier paragraph, we of course whatever before any declaration of an agroecosystem is made, we will have to ensure that all the scientific processes are carried out, and to ensure that consultation is made, to ensure that it becomes a thorough and transparent consultative process, and that on top of that, it can be challenged. So we'll put scientific processes that whoever challenges would have to challenge it from that scientific background. Any further development, if we say, if our members allow me to just explain, simplify this area, if the owner of the land does not think that that which they are to embark upon affects the value of or the capability of the land concerned, we will then go into discussion first, consultation, and later on we'll go into science. At the moment, such activities are regulated, be they in terms of NEMA or in terms of our law of the CAR, the Conservation of Agricultural Resources Act, or even under Subdivision of Agricultural Land Act. So we still already, the area is regulated. We cannot willy-nilly change land use. We cannot willy-nilly in this country bring upon a land any activity without that is towards the change of the use of that land without authorization. So the area is already regulated. Compliance burden, always when we formulate law, we come across this, the area where the compliance burden in this, according to the House, in this provision, is in contrast with the commitment from the government dedication to do away with processes. Unfortunately, honourable members, this is one area where, unfortunately, there has to be a process. Much as it is the intention of this country to make it easy for anybody to do business with in the country, much as it is the vision of this current government to ensure that there are unnecessary red tapes. We agree and we understand. But in this specific case, because of the complications and the complexity of the processes that ought to be followed, in this specific case, because of what has happened already where high-value agricultural land was lost, it has become necessary for us to have to come with this bill, into this bill, make a provision through this bill of ensuring that the process unfortunately becomes thorough, and that, of course, if a land owner wants to change the land use, we've got to unfortunately go through this burden. It's one of those few areas where we cannot do away with the compliance burden, because if we do that, it then becomes land that anybody can do what they want to do. And we have learned up to this stage that we've lost high-value agricultural land to other things. So it is unfortunately one of those areas that we cannot look away. Listing of agricultural activity, again, this is one of the areas that the House feels that the minister, they wouldn't prefer for minister to list an activity requiring agricultural authorization. But again, we are saying we note the comment, but the activities will have to, to be performed, will have to be looked into before, and we'll have to be convinced that the activities that are listed or a procedure for listing such agricultural activity, we've got to get hold of it. We've got to understand. Members would also remember that there would be call it a register of all high-value agricultural land in the country. And throughout the process, if we hope for the bill to be enacted, and once that happens, we're going to embark on a thorough consultative process of listing all land, and everything else would be known. So, but we understand the fear from the House, because it does look, they seem to be understanding to me that the department will just go ahead and prevent actual development of the land and actual activities that they would normally go about. But that's not the case, because there will be an opportunity for written comment. There will be an opportunity for consultation. There will also be an opportunity for representation. Since this law will be applicable to all agricultural land, everyone who owns land must be consulted when policy decisions. Of course, this we agree with. When listing is conducted, all written comments will be considered, as well as representation. Content of agricultural that the system that we're going to have. The House says clause 26G states that the information regarding the landowner or land user that must be recorded in the National Agricultural Information System may include the nationality and gender of the landowner or user. We note the comment, but like we said, this bill does not aim to address land ownership. There are other laws that address land ownership. This bill aims to preserve the high-value agricultural land that we already have, that high-value agricultural land that is under the ownership of different persons, juristic or natural, of different companies and different landowners in their own different categories. Whatever land that is held or is owned by those, the intention of the bill is to make sure that such land, if it's of a higher agricultural value, it's so preserved. So this is one area where perhaps the House might not have understood the intention of the clause. They are also of the view that the bill should strictly regulate the sale of agricultural land to foreigners who lack permanent residence, and further that the interest of the emerging farmers should be prioritized before considering foreign nationals. Again, this bill is not about land ownership, much as we understand where the House comes from. Unfortunately, this is not within the scope of this bill. Up to this point, honorable members, honorable chairperson, that's what we've been able to put together as a response to the written submissions by the National House of the Traditional and Khoi-San leadership. If the chairperson agrees, members agrees, honorable chairperson, we would love to continue with our response to the questions raised by the Department of Forestry, Fisheries and Environment, which is the slide that follows. We will take those. And like I said, when we started, we brought them together because their questioning and the approach is similar, honorable chairperson. May we continue to the next part?
Yes, please continue, and Dr. Serrache will take both the presentations, and we will also request our legal services from Parliament and State to also respond on these two submissions after you're done. So
Thank
proceed.
You very much,
Thank you.
Thank you very much, Honorable Chairperson. Now, here we start with the responses to the written submissions by the Minister of Forestry, or DFFE Minister. We need to also point out in the beginning and the outset that the Minister had already written to her counterpart, Minister of Agriculture, Land Reform and Rural Development, and that a written submission has been, or a written response has already been sent to the Minister. But we also noted that the same contents that were submitted to Minister were already sent to this August House, or this August Committee. And also that throughout the process, when the bill was enacted back then, the department or the competency of environment, which is was part of another department and now is part of the Department of Forestry, Fisheries and Environment, was consulted thoroughly. And in fact, they formed part of the main stakeholders that had to be consulted. So there was a thorough consultation. But lately, we then received, our minister received the written comment, and the same comment, similar comments were submitted to this August committee. Our responses are as follows. According to the Department of Forestry, Fisheries and Environment, they've got a difficulty with the identification of activities requiring agro-authorization. They're saying, it is stated that the identification of activities requiring agro-authorization for persons conducting agricultural activities, they do not support that this be authorized by this department. We understand that before PDAL, to some degree, the Department of DFFE was making to some extent authorizing agro authorization. Basically, they were not necessarily authorizing, but they would look at proposed land use with a view of them being trying to protect agro ecosystems. But we know that the provisions of this current bill are not supported, they don't support, but in short, honorable members, the department with mandates and competency to authorize agro authorizations, our view is that it is the Department of Agriculture, Land Reform and Rural Development. So much as they may have had some area where they participated as far as agro authorizations are concerned, we still feel that those, if this bill becomes enacted, what they are currently doing as far as agro authorization is concerned would then have to be either consulted through us, or us meaning DARAT, or simply be amended on their part, because we believe that the competency, the technical competency and the authority of agro authorization lies with this department. Further on, they're saying saying that it's stated that identification of activities requiring agro authorization. Also, they are not supporting the clause in our bill that the Department, Agriculture, Land Reform and Rural Development, be declared or a competent authority to authorize agro, or to grant agro authorizations or related activities. And when we were developing this bill, we had noted authorization that the DFFE department was providing in terms of the NEMA Act, and that unfortunately those that were basically environmental authorization, as members would know, for in the main environmental impact assessment, the related activities, and we noted those. But those authorizations are not specific to agriculture, and therefore they would not have, and I'm glad that the Honorable Chairperson would also consult legal, that whatever authorization, in other words, the EIA, environmental impact assessment and related authorizations, are not necessarily agricultural authorizations. So at the moment, there was in the country, the gray area, or the area where the Department of Agriculture, Land Reform and Rural Development was not occupying that space clearly and thoroughly, hence the understanding, which in our belief, of DFFE, Department of Forestry, Fisheries and Environment, that they were already making agricultural authorizations, but we don't believe they were doing it adequately, and we also don't believe, honorable members and honorable chairperson, that Department of the Environment, Fisheries, Forest and Environment can make agricultural regulations, agricultural authorizations, when there is already a competent department. They also are not in agreement that, as they say that in their letter, that the provisions of the bill in respect of are not supported because their act makes such provision. In the same matter like I addressed before, we understand and accept that one of the reasons why we've had to come up with PDAL was because our laws, the laws that are under the administration of this department at the moment, were not sufficiently enabled to regulate this area. So they may have to some extent been performing activities in this area, but it is because we did not have the law of our own. So with this new bill, we want to create a whole agro ecosystem management, and to ensure that we manage it and ensure that, because we are the department charged with the mandate and authorization and authority of regulating agricultural activities, we think it then should become the functions that they currently may, by implication, not necessarily performing, that they, by implication, may be playing a role around. We feel that is they should be seeded if they were, but we don't think they were doing thoroughly. It was just by implication, but we feel that entire responsibility should be ceded to this department, because this department will be, amongst other than having the competency, other than having developing the new law that will allow us to have a system that will allow us to be able to regulate the entire agricultural activity and the entire agro ecosystem. We feel this should be the department that is authorized. In fact, when the legal people will be going into this matter, we anticipate them being able to clearly delineate the mandate, and the fact that they were not challenged for the activities does not make it that they actually were competent to authorize agro ecosystems and agricultural activities. Again, they say according to this department, the FFE, the environmental impact assessment regulations that they published in 2014 and the listing notices made in terms of those regulations, they say this already include agricultural activities. All members would notice already include. So whether they were included, which there's nothing wrong with different departments. As we had a comment, in fact, we had advice from the Office of Chief Law State Advisor about a scenario where we thought it was a problem for two pieces of legislation by different departments to regulate the same area. In fact, the response we got was that there's nothing wrong as long as there's no clash. And in this specific area, one of my members on the chairperson, they say include. So include may not necessarily mean it was thoroughly catered for. And with this bill, we intend to create a whole agro ecosystem, its management and information system. So they may not have, even if they were the activity, the EIA activities were implying to a greater extent agricultural activities, they were not succinctly and clearly covering the management and the information system that this bill, if enacted into law, will provide for. Last, and again, they're saying it is further stated that agricultural activities require listing. They say DARAT would identify them and request Minister of Forestry, Fisheries and Environment to list them. And we find this very, I don't want to say odd, but we find it very, very illogical that you'd have the minister that is not responsible and not charged with agricultural responsibility to be the one that authorizes agricultural activities, and also authorizing the minister who would be charged with agricultural mandate and responsibility. We just find it very illogical, and that our submission is that whatever that they either would continue to do what they're currently doing, which would mean some of their EIA authorization would imply agricultural regulation of agricultural activities. That shouldn't be a problem for as long as there's a competent department with a mandate and authority to regulate agricultural production does that. And also with time, they would realize that in fact, they would not even have the agro ecosystem authorization. They would not have the system. They do not have at the moment the system that we intend to have enacted as part of this bill. The system which would register and classify after declaration of all high value agricultural land, and would know before any activity happens that that part of the land up to the detailed geolocation would know that that part of the country, that part of the land is a high value agricultural land and cannot be used for anything else. In fact, this approach would assist their EIA. In fact, the consultation should be the other way around. We submit that they should, before they even embark on EIA process, we think they should rather than consult us, so that by that time we'll be having the system, and on a touch of a button, we should be able to tell them that up to that granular geolocation, that this land is high value, and that will make their EIA assessment quicker. New decision-making process. They're saying the introduction of a new decision-making process through this bill, which involves the listing of activities for agroecosystem. They do not support it. But we say, as per the above ecosystem, that the ones that I've explained, the process of the agroecosystem authorization and other authorizations that will be following, we feel that those becomes agricultural matters. And like I said earlier, it will be odd if a department whose mandate already in terms of Conservation of Agricultural Resources Act of 1983, already in terms of Subdivision of Agricultural Land of 1970, is already authorized and given authority to regulate agricultural activities and any other related activities. We feel it will be very odd that such department is not empowered to make decisions on agroecosystems and related activities. Towards the end, honorable members, honorable chairperson, they say the new decision-making process again, they say the introduction of new decision-making process again, where it involves the listing of activities and agroecosystems for operations. They don't support that. And we consider that upon commencement of this legislation, the activities that they are currently doing will in fact become beyond their scope, because it is within the scope of this department. And again, they may have implied in their authorization, agricultural authorization. It does not make it their mandate and responsibility. And it is not expected of them to have agricultural competency, in fact. So whatever they're doing, because perhaps it has not been challenged, it does not necessarily make it correct practice in terms of the laws of the country, because we feel the mandate, even without PDAL, the mandate of agricultural regulations falls within this department. We therefore submit, Honorable Chairperson and members, that we've considered all comments, and we went through all of them thoroughly, the comments from the National House of the Regional and Khoi-San leadership, and we also considered the comments from the Minister of Forestry, Fisheries and Environment, and we went thoroughly through to them with a positive approach. But we unfortunately, as we have stated in our presentation, in our word format, we unfortunately cannot concede or accede to their representation and comments, because we still feel this country requires PDAL. This country, in order for us to continue to preserve and protect the land, high value agricultural land, that part of which we have already lost, we feel this country has got to enact a law that ensures that high value agricultural land, irrespective of who owns that land, should be protected for and should be set aside and preserved for agricultural food production purposes. We submit, Chairperson. Honorable, back to you, Honorable Squatcher. I'm not sure if Honorable Minister joined us, but we submit, Chairperson. Thank you very much.
Thank you, Dr. Serache. Honorable members, that is the presentation from the Department of Agriculture, Land Reform and Rural Development. I will now invite our Parliamentary Legal Services and State Law Advisor to give input on the presentations submissions that were made by the National House of Traditional Leaders, as well as the ministries of forestry and fisheries, as well as environment.
Yes. Who is he taking? Is it us?
Thanks, Chair. Good morning. This is Zingisa Zenani, and I am with my senior legal advisor, Siviwe Njikela. I'm going to hand over to him to respond to the two presentations that have been made by the department and where we stand so far. Thanks, Chair.
Good morning, Chairperson and the members of the committee. As my colleague has said, I'm Siviwe Njikela. Chair, we propose to deal with the issues in this manner. One is the apparent differences between the executive, if I may put it that way. And then we may, after that, deal with the technical issues that are being raised in as far as the content of the bill itself is concerned. Chair, what has become apparent now, there seems to be some differences in terms of approach between the departments, which puts us in a very difficult position. For the simple reason, Chairperson, that when a bill is introduced in Parliament, it is assumed that within the executive level, there has been sufficient consultation and deliberation. And that's why the bill ends up in Parliament. So it does become a little bit tricky for Parliament as a separate arm of government to have to deal with whatever differences may be existing between the departments. And for that reason, Chairperson, we do not propose to deal with those. If we are pushed to the point of having to deal with the apparent differences between the departments, we will request, Chairperson, that we be given enough time for us to engage with the presentations so that we can be able to appropriately advise the committee on perhaps the best way to proceed. But, Chairperson, it will be preferable that the executive settles whatever differences may be there on its own and comes to Parliament with a concrete position that is agreed between the departments. It is a little bit awkward for us to make an intervention in that respect. I hope, Chairperson, that assisting as far as the apparent differences may be concerned. Chairperson, we are quite satisfied that a lot of issues have been raised, but we believe that we will need further time as the legal services of Parliament to consider all the presentations that have been made today, consolidate our position, and advise and guide the committee in terms of what we think legally is possible. And we will request the chairperson's indulgence that we be provided that opportunity to consider all those issues and come back to the committee with a concrete proposal on how we should be interacting with the submissions that have been made. Chairperson, if I'm leaving anything out, I will invite my colleague Zingisa to just make some comments in respect of the issues that I may have left out. Through you, Chairperson.
Thanks, Chair. I think my senior has covered everything that I was going to say and confirm that our request that we be given more time to make a thorough and presentation on the on our responses. Thanks, Chair.
Thank you. Any further input from the State Law Advisor? Bao van Breda, you
Yes,
covered?
Chair. Yes, Chair. I think I can concur with my colleagues in the Parliamentary Legal Services with regards to the submissions made by the DFFE. Chair, that is, of course, an intergovernmental issue. I don't think it would be appropriate for me to comment thereon. The department has addressed those submissions, and I think it's for the committee to really consider those submissions. That is an intergovernmental matter, but I think I am satisfied with their response that there should not be a conflict, and that the objects of the bill do indeed fall within the mandate of the department. But that is the only input I'd like to provide in that regard. Chair, with regards to the submissions made by the National House of Traditional Leaders, I'm also satisfied with the department's response. I believe that the bill does provide or does make provision to allow for traditional communities to make inputs, written representations in respect of proposed declarations of protected agricultural areas, as well as proposed listed activities, Chair. Chair, there was another concern raised by the National House with regards to limitation of land rights or property rights. Chair, with regards to that concern, the only concern that may arise, Chair, is in respect of the declaration of listing of a listed activity, and not in respect of a protected agricultural area, because the activities, it's only the activities that are listed which may possibly limit the enjoyment of property. Now, it must be noted by the committee that in terms of clause 16.2, the only activities that may be listed by the minister are activities which may have a permanent negative impact on the agricultural potential, capability, suitability, or the use of agricultural land. Furthermore, the minister may list activities which do not require agro-ecosystem authorization. Now, the bill does make provision for interested parties to provide written comments on proposed listed activities, and such comments must, of course, be considered by the minister. Now, there is a just administrative process in the bill, and persons who are, of course, not satisfied with the outcome of an application for an agro-ecosystem authorization may lodge an appeal with the minister. And of course, if a person is unsatisfied with the outcome of such an appeal, there is the option of judicial review of the decision. Regarding the possible limitation of a property right, should it be shown in court that there was indeed a limitation of a property right, the department would, of course, have to show that such limitation was reasonable and justifiable in terms of Section 36 of the Constitution. Now, of course, a court is bound by the Constitution and must make a rational decision in accordance with the Constitution, and must ensure that such deprivation is not arbitrary and that it is justifiable. So, Chair, I am satisfied with the department's response, and that there are indeed safeguards with regards to any possible limitation of a property right with regards to the declaration of a protected agricultural area or the listing of an activity. Thank you, Chair.
Thank you, Honorable members, that's the presentation. I see the hand of Umphathiswa. Wamutitiza.
Good morning, Slalo and our members. Apologies that I joined the meeting late, been through my network, Slalo. No, I've listened to the legal team of Parliament, and I was going to say it might help before they come to Parliament just to indicate to us what are those areas of differences so that I can speak with my colleague at DEF and see how we can manage those and then maybe give a joint response to you, if the chair would agree and the members.
No, thank you, Mphathiswa. Honorable members, that is Mamutitiza, the Minister in the Department of Agriculture, Land Reform and Rural Development. Having had the presentations from the department regarding the submissions that have been received from the National House of Traditional Leaders, as well as that from the Ministry of Environmental Affairs and the Ministry of Forestry and Fisheries. We have also received the input and presentation from the legal advisors to Parliament and State Law Advisor. We will now open the session for questions of clarity or comments on the submissions. Honorable Kape.
Thank you, Chair. And good morning to your good selves, honorable members, the executive, and everybody who's following this discussion. Chair, let me appreciate and really commend the National House of Traditional Leaders and Khoi-San for having cooperated on the courtesy that we extended to them and really made their submission or their voice heard on this bill. I am satisfied, Chair, with the responses from the department on issues they raised, as also being put at ease by the State Law Advisor. I like it, Chair, when everything else points that even on this agroecosystems authorization and everything, making sure that we also identify high agricultural and everything will be done scientific. The concern or the submission was also made, Chair, earlier on the discussion of this bill, that we must not leave this leadership at the back when the minister does or formulate a panel of advisors. I don't know if it's chapter 6 or 7, where it deals about contraventions, compliances, and putting up advisory panels. And I think doing that will make sure that they are taken on board every step of the way. I also agree, Chair, with the department that we must be firm on issues of compliance. We know, Chair, that it's not every leader, traditional leader or a Khoi-San leader, but in some instances, we find CPAs running the shows, and they are notorious of allocating land to developers and everything. So we cannot relent on issues of compliance if we want to achieve the object of this bill. So I agree that that should stay. Chair, the minister has responded to how we can deal with the issue of the other department, environment unit in a way, forestry and fishery, which was once part of this. It will be very unfortunate, Chair, if on the mandate of that department, they have elements of agriculture. It will be very unfortunate. I understand fully where the department is coming from, and I support that agricultural authorizations or activities be regulated or be done within this department. It will be very unfortunate, even if it would mean that some of the delegated powers has been sent to agriculture to that department. But be as it may be, the legal team is saying they need time to advise us on this one. The minister has got a short-circuiting response to that will help us a lot, that they deal with that as two cabinet ministers. Having said that, Chair, I submit. Thank you.
Thank you, Honorable Klape. The Honorable Ntate Masipa.
Thank you, Chairperson, and good morning, colleagues, and good morning, Minister and Deputy Ministers and the department officials. Chair, I would also like to really welcome the presentation. I'm just taken aback a little bit with regards to some of the developments from the statement from the legal advisor, where really they are advising that this situation require a separation of powers, that the ministers must discuss, and obviously thereafter they will be able to comment. As far as I'm concerned, the bill is in our hands, and we can obviously, ask the ministers to provide us with the answers needed if we need answers. Chair, I just want to really go to on the Constitution in terms of environment. It says that the environment, everyone has the right to have the environment protected for the benefit of present and future generations. So I'm just quoting this, Chair, because I really do believe that we need to protect agricultural land. And I think our concern at the moment is that who is responsible for protecting this agricultural land. It is my opinion that, Environment Department has got power on, many other areas of agriculture. But I think for agriculture really to really survive at the moment, there are certain powers that really needs to devolve and come into agriculture for agriculture really to be able to be sustainable. Chair, we have seen the complaints during our public hearing from members of the community, especially in the communal areas, around the issue of their land being taken by mining, by other areas as such, An environment department is there, obviously, to issue those licenses or to do environmental assessment. And my worry is that most of those things were really ignored. So, Chair, my submission really is that, I do think I agree with the department that we definitely need some level of powers that we can have as a Department of Agriculture in terms of really managing agricultural land. That's very important. However, Chair, my one concern is the submission of the traditional leaders, and I've just noted one that they talk about 13% and agriculture, except the one in the hands of the traditional tribal authorities. There, Chair, I have got a problem because, this bill, the way it's drafted, many of the issues are going to be resolved through regulations. And when these regulations will come into place, whether they are ready or they are not ready, we do not know. My concern is that even in this, where the traditional or tribal authorities want to be in charge of various activities with regards to their land, they have been, without even this bill, but they have been allowing land being invaded by businesses and so forth and so on. So that's really my concern and my submission, that really I think there is a level of speed that is required to really ensure that some of these things, come into place as soon as possible, especially on communal land where people feel that their agricultural land is invaded. I do not know, and I hope that this is not going to really create some constitutional problems. But as far as I'm concerned, the bill does not have really constitutional issues. It's just the implementation issues that needs to be ironed out as soon as possible. So, Chair, really, I think those are my inputs. Not really a specific question, but I just want to really emphasize the importance of really having to protect agricultural land, really for the benefit of our communities and our agriculture and our farmers as well. And what is important is that the matters that are before us with regards to environment and the department, if they can be resolved sooner, if both the Minister of the Environmental Forestry, we need to ask her and Minister Togodidisa to appear before us and maybe just brief us jointly, so that we can move really with regards to this bill. We don't want to find a situation where the bill is subjected to court. But I think we got to just make sure that we tick all our boxes that are required to be ticked to ensure that we process this bill. Thanks, Chair.
Thank you, Dr. Masipa. The Honorable Charter. Mamutrete. The Honorable Bautapa.
Thank you, Chair. Good morning to you, Chair, and everyone, to the Minister, Deputy Minister, Department, legal advisors, and all our staff, and all my colleagues. First of all, let me appreciate the input by the legal advisors. To me, it was very informative, and it is telling that work has been done, especially in addressing the two issues from the traditional leaders and from the Environmental Affairs Department. Firstly, it also helps that in this case, the traditional councils, to me, ought to have understood that it is helpful for them that the land that they are using or they have authority on is already to be protected by an act. And therefore, that gives them some power and strength that the land is already protected, rather than looking at it as some competition. And therefore, I take it that it is this explanation helps and strengthens the zero authority that they are talking about. Although I'm worried about the speaking of 13%, as if it is accepted that this only 13% that remained during the dispossession is something we can be proud of. But the department, to me, and the legal advisors have done good work, which explains, and therefore, together with the Department of Environmental Affairs and Forest and Fisheries and Environmental Affairs, it is important also to me to note that the position that the minister is taking is very important, but it is also interesting to me that did the department, to some extent, seek for any advice or legal advice for the department before they take the position in this legislation? But one thing important here is that it is important that the executive, it is true that they should get themselves a common understanding and clear understanding on the legislation, on the positions they take before it comes to the committee or to the committees. Because as this department is putting in front of us, it is clear that the intention here is the preservation and protection of this land, which is in the interest of everyone. And therefore, it should be at no stage be taken as if there is a competition between the departments. That is why I think even the Department of Internal Affairs should be happy when they find that some work is already been done for them in protection or in relation to the environmental issues, just because of the issue of the agriculture and land. But it is important, therefore, at the same time, that the executive come together and have a mutual understanding and make sure that the issue of the land protected in agriculture is not any ground for competition. But it is very good that the explanations or the answers or responses to all the inputs that were there, to me, that are very clear, especially that they are always related, that this one has been attended to, this one is related to, and also the fact that it is emphasized that this bill is for the protection of agricultural land and nothing else, because it is a problem when it is mixed with land administration, because that is what is being happening now, especially with the transitional authorities, about administration, and yet here is the protection. I thank you, Chair.
Enkosi Mthembu. The Honorable Mamu Babama.
Thank you very much, Chair, and allow me to say all protocol observed. I do not have much to say, Chair, today. I agree with what my colleague has said, and I do not dispute what others have said as well. So I honestly have no comments on this one, Chair. Thank you.
Thank you, Mamu Babama. The Honorable Ubao Dlamini Sibalko. Sibalko. The Honorable Tate Matthias. Tate Matthias.
Thank you so much, Honorable Chair. Greetings to your good self and to your highness and the members of the committee, the minister and the deputy ministers present, government officials and our colleagues in the portfolio committee, Dr. Manenze and other dignitaries in the meeting. Well, I've been listening and taking notes of the presentation. Just equally want to express what we have always said before, that land must be protected and it must be used with care for the benefit of the future generation. And where government has to act in a way of formulation of legislation and regulation that will help in the preservation and careful utilization of land, especially for agricultural purposes. Government should act, and in acting must ensure that there's a fair, balanced distribution of land for all purposes, whether for agricultural, industrial, residential, or commercial, taking into account the needs of our people as the needs develops and evolves over time. A piece of land which might have been used for decades for agriculture and has not been utilized, has lied fallow, and has not been tended productively, and may today not longer be useful for agricultural purposes. Legislation and regulations must be flexible to take into account such changes and must be able to take into account societal needs as they evolve over a period of time to accommodate such within a regulated environment. I think if this is taken forward in the legislation, I think all country will be happy with what government proposes and brings forth as means of intervention. With those few words, Honorable Chair, I would want to thank you for the opportunity given to us to make a contribution. Thank you so much.
Thank you, Honorable Matthias. Agbare Breed.
Môre voorsitter,
Goeiemôre, hoe gaan dit vandag?
dit gaan goed. Net warm in Bloemfontein, maar dit gaan goed. Chairperson, I want to thank the presenters for the presentation, and I think it was quite clear the stance of the department in terms of the inputs that were made by the National House of Traditional Leaders and the Department of Forestry, Fisheries and the Environment. And I think my colleagues have covered questions, so I am good for today. Thanks.
Thank you, Agbare Breed. The Honorable Memasho. You are not audible, Memasho. Memasho, we can't hear you.
All right, can you hear me now?
Yes, thank you.
All right, thank you, Chair. Let me say thank you very much and also send my greetings to honorable members on the platform, including yourself, Chair, and then the officials of the department. Chair, I have been listening to the presentation. One would like to acknowledge and appreciate the presentations from our departments, including our legal teams. What they have said, I think, satisfies me. And I think my colleagues have already touched on some of the most important issues that one wanted to raise. Papa Tlhape, Kapa and Methape, including Membama, all of us, I think what they raised, it satisfied me. I don't have anything to say here, really. They covered me. Thank you very much.
Thank you, Honorable Marshall. Ndabezitha, Nkosi enkulu, the Honorable Cebekulu. The Honorable Cebekulu. The Honorable Ntate Montwedi. The Honorable Montwedi. Any other honorable member on the platform I've not recognized? If not, if no further questions of clarity, before I hand over for responses on the matters raised by honorable members, I would first and foremost want to honorable members to note that these stakeholder submissions were sent to our legal services as and when we received them. And the submissions from the Minister of Environment as well as Forestry and Fisheries were also sent to legal services around early October. And therefore, it is unacceptable for them to tell us that they are not ready in terms of processing and proceeding with these submissions. It is, honorable members, a real serious concern that they've not looked at it and now wants more time to engage with this. I think we need to ask the questions amongst ourselves, honorable members, as to how do we proceed from here, because this has taken the much needed time to ensure that we are able to engage on these matters, and we can no longer be postponing these issues, as we need to conclude our work in particular around this bill. So before I hand over to the department and the legal services for responses, I'd like to ascertain as to when will this be attended to, because my real issue here is that the legal advisors should revert back to the committee no later than Friday morning. I do note that we have mini plenaries that are scheduled for Friday, but they should afford us responses by no later than close of business day on Friday. And we should schedule this for next Tuesday to ensure that we proceed with the work that is before the committee. Any inputs, honorable members? I'd like to see hands, if any. Date Masipa.
Chair, thank you very much. I think I fully agree with your input that we need the response. I was just wondering if, Chair, I don't know how the minister's process is going to work in terms of coming back to us. And I was just thinking that maybe if the environmental department want to do a presentation, be given an opportunity maybe to do that. And then when we do the A list, at least, we just kind of move, because I think the issue is how we can't really stop this. We are really very far. We need to get their inputs as to what is that they object, what is that they need us to really maybe consider, and then we can really make a concession in terms of the areas that they feel are under their control. But there are definitely lots of areas that we need to take over from them. That I agree with the department fully. But my request, I do not know, but I was just wondering if we can have the department, what you call fisheries, to just engage them. We don't want to find departments taking each other to court, at the end once we have finalized this bill, because that's what you don't want, Chair, and we don't want as a committee. Thank you very much.
Thank you, Honorable Ndate Masipa, for the input. The Honorable Tlhape. Dr. Tlhape.
Thank you, Chair. This gadget. Chair, I agree with you that the legal service had enough time You know, this submission was part of the submissions that were discussed or tabled when we did physical, when all those other stakeholders were there. This report was there. Now, one, the department, through Ntate Srage, is saying they have sent the responses to the Department of Environment. Probably is for them to make follow-up if the Department of Environment is also satisfied with that, since the minister saying she will be checking with her counterparts on such issues. But I agree with Honorable Masipa, we don't have time, Chair, and we cannot relent. If it was not for this, we would be making a commendable progress, because between us, it has been an issue that we did courtesy to the traditional leadership and Khoi-San leadership. So, Chair, I don't know how soon this can be done, because now I would suggest that for our interest sake and progress of this committee, we could look at just having an hour on Thursday evening to deal with this matter, so that Friday we are progressing with whatever we would have handled, so that it doesn't delay the processing of this bill. We don't have time, Chair. So I would request your good self and your team to say, let's dedicate an hour post our day for Thursday, just to deal with this matter, so that it doesn't hinder the progress that we would want to make on Friday. Thank you, Chair.
Thank you, Honorable Dr. Tlape.
Yeah, the progress for Tuesday, not Friday, because Friday is mini plenaries. We don't have time. Thanks, Chair.
Thank you, Dr. Tlape. The Honorable Kapa.
Thank you, Chair. I concur with these inputs. You remember that this part of the legal advice or legal services, I treated it with kid gloves, because I could sense, in my sense was that they are just afraid of bringing the departments against each other, or executives against each other. And therefore, for that reason, they did not, or they are afraid or reluctant to do their work. And therefore, that's why I not even comment on the delay that they are asking. I don't think it will assist us. The only thing that the compromise here is that the executive, the minister, must talk and resolve this within a very short time. Otherwise, I agree that we don't have enough time to drag on this, and therefore, I'm taking seriously the responses and the inputs that were done by the department. I thank you, Chair.
Thank you, Honorable Kapa. I see at the hand of the Parliamentary Services, Mamo Zenani. Mamo Zenani.
Thanks, Chair. First, perhaps it will be proper for us to apologize if we come across as delaying the process. We, perhaps from our side, did not want to come across as if we are being dismissive of particularly the submissions that have been made by the National House. Our response would have been short, and perhaps we wanted to formalize it, but if this committee feels that we can make our input now so that they can be processed, then we can do that. However, I must also state that the submissions by the National House are not raising anything new that has not been discussed previously and deliberated upon. The National House brings about the issues of consultations and perhaps seem to suggest that they should be amongst the group that is that is specified in the Act for consultation. That's one thing. Deliberations have been made in this committee that they will not be excluded. They will be included amongst the groups that are mentioned for consultation. The bill in itself is consultative in nature. So we felt that perhaps that is not a new proposal. It's something that has been deliberated upon and considered. The other issue that the submission brings about is the issue of the mandate. They raise an issue, they raise a point that perhaps a point relating to clause 26G, where they are saying that the bill should strictly regulate the sale of agricultural land to foreigners who lack residential permit. Again, we feel that the department has responded appropriately to that comment, in the sense that the purpose of the bill is to preserve and to protect agricultural land. It does not necessarily deal with land ownership and sale of land. I do not know if there is anything perhaps that the committee would like me to add on that. But as I said, we had thought that perhaps we would be required to make a formal submission, and that is why we requested more time. That is just in relation to the submission by the National House Chair. Thanks.
Honorable Masipa, I see your hand. I was gonna allow the department to respond also before we come to follow-up questions.
Okay, Chair. Sorry. Yeah, it's fine. I will do a follow-up question. It is a follow-up question. Apologies.
No, that's fine. Let's take all the follow-up questions once we've received the responses from the department. Honorable members, the executive is requested to be excused as they are going into a cabinet committee meeting, and they've left the officials to proceed with the responses. Allow me to therefore invite Dr. Serache to proceed with the responses or comments.
Thank you, Honorable Chairperson and Honorable members, and the Parliamentary Legal Support Team and the team from Legal Services from DALRAT and colleagues. We appreciate the opportunity granted to us by this August committee. We also want to emphasize that the matters as raised by the National House of the Traditional Khoi-San leadership, as already my colleague from Legal Services of Parliament have already elaborated on, they really were not issues that were strictly contrary to the object of the bill, and we are willing that we will make time to take them through and assure them that their rights will not be lost at all, and that the bill actually, like Honorable Kappa said, the bill actually helps them to be able to have the land in their possession be productive and be protected. I think the main issue that we need to the guidance and assistance of this committee on is with regard to DFFE. And there's the 2 points that they are raising, like we've already said. Minister has written to Minister that we'll just trace how far the process is, because we think it's not the entire DFFE. It might just be certain individuals within the DFFE, and we'll also try at the DDG and 2DDG level to find each other while the process of ministers is unfolding. We hope that if we tried at that level, we might. And this came as a shock, honorable members, because DFFE, the erstwhile environment, have been consulted as far back as 2014 when the bill started, and they've been in support throughout the process. They've supported us, everything that we put in the bill, and they acknowledge that it's part that they are, it was beyond the scope of their laws, and they were in agreement. The two things that they have a difficulty on is with regard to agro-ecosystem, and which is we still submit that it is the responsibility of the Minister of Agriculture, because the Minister of Agriculture would have the necessary competencies to be able to declare agricultural land for agricultural purpose, and also to differentiate the purpose of the agricultural purpose use and environmental services. Is not within that scope. So we will really try from our side, and we are humbled by the support of this committee, and we'll try at our technical level and see if we cannot have them withdrawing this, because we really were taken by surprise that they would raise the matters like they've raised on those 2 points, Chairperson. Unless if, with your indulgence, we've got also legislation specialists from Darat, Advocate Ramasala. If with your indulgence, there's a matter that he think I may have missed. Advocate Ramasala, if you are here, if you think there's a matter I missed which you think the committee needs to be aware of. It looks like it's not here, Honorable Chairperson, Honorable Members. We so submit, and like I said, we will try by all means to reach out to DFFE, because we don't think the matters that they are raising at all encroach on their responsibility. It's rather the opposite. What they're doing and what they've been purporting to be doing are agricultural activities and not environmental activities. And there's a clear delineation in our country's laws of what environmental protection is and what agricultural, and in terms of Conservation of Agricultural Resources Act, we know our bounds when we administer that law. So we've never had challenges with them. And similarly, when they administer their laws, we've not had the situations like we have now. We submit, Chairperson, with that note. Thank you.
Thank you, and Dr. Serache. Honorable members, that is the responses from the Department of Agriculture, Land Reform and Rural Development. I see a hand again from Mamu Zenani, our Parliamentary Legal Services.
Thanks, Chair. My apologies. It was a legacy hand, but perhaps to reiterate that the deliberation on the submission by the National House is perhaps done, is not necessarily done under the auspices of a referral that has been made in terms of the joint rules, which is rule number 165A, and that the submission is done as a result of the courtesy that was extended to the House to make their submissions. Perhaps to reiterate on the issue or the submissions by the Department of Environmental Affairs and Fisheries, that it is our strong view that this is an intergovernmental issue that needs to be resolved between the two departments. Thanks, Chair.
Thank you, Mamu Zenani. Honorable members, there is responses from the Department and Legal Services. Any follow-up questions? We'll make it easy if you can put a show of hands for follow-up questions. Honorable Masipa.
Chair, thanks very much. Thanks to the responses that we've received. Chair, I think my follow-up question was really very simple and straightforward. It was to just inquire whether we've got a constitutionality matter here with regards to agriculture and forestry. Obviously, forestry arguing that they have got the mandate to obviously execute certain tasks within the agroecology assessment, whatever you call it. I think that's the big key question that I think legal advice should have provided us with. If we have hit a constitutionality problem here, because I think, like I said, the implementation matters are really just a concern for me, that a lot is going to be done through regulations. But otherwise, I think from implementation side, we will obviously have those challenges. But I just wanted us to really make sure that we are certain that from a constitutionality point of view, can we go ahead? I think that's where the legal advice should provide us really a substance answer. Thanks, Chair.
Thank you, Honorable Ntate Masipa. Any further follow-up questions, honorable members?
Thank you, Chair. This is Kapa.
Please go ahead, Honorable Kapa.
So I think I raised this question, but there was no response. I wanted to know if the Department of Environmental Affairs did seek any advice or any legal advice in this matter, or they just straight communicated with the minister and might seek advice later. What is the position here? Thank you, Chair.
Thank you, Honorable Kapa. Any further follow-up questions? Zenani, Parliamentary Legal Services, any constitutional issues here that we may need to look into?
Chair, in my view, there are not any constitutional issues that may arise in the issue that has been raised, the issue of mandate that has been raised between the Department of Environmental Affairs and this department. And that we believe that if it is clear under whose mandate a certain activity falls, then nothing cannot be resolved through the intergovernmental process between the two departments. That is our view, Chair.
Thank you, Zenani. I see the hand of the State Law Advisor, Ntate van Breda.
Thank you, Chair. Chair, I concur with my colleague with regards to the constitutionality issue. Chair, just in addition to my inputs regarding the submissions from the DFFE, Chair, what I just wanted to add is that the purpose of the bill is not to provide for the protection of the environment in terms of Section 24 of the Constitution. Its purpose, Chair, is to give effect to Section 27(1)(b) of the Constitution, which is to ensure that everyone has sufficient access to food. It may, of course, benefit the environment, but that is not its purpose, Chair. And I reiterate that I am satisfied that the objects of the bill, as well as the manner of its implementation, falls within the mandate of the department, and that there are no constitutional issues in this regard. Thank you, Chair.
Thank you, van Breda. Ntate Serage and officials of the department.
Thank you, Honorable Chairperson. Yes, thank you very much. In fact, when we started at the beginning, the Office of the Chief State Law Advisor had dealt with that. There is no constitution. They assured us that there are no constitutional issues. And in fact, even the matters that they are purporting to be presiding on, they are not in their principal legislation. It is a part of their subordinate legislation, which for some reasons, which we will engage them and understand why have they been wanting to do that, because we had all instruments in our law to be able to cater for that. So I just want to reiterate that at the start of this bill, we were assured by the Oxlade that there are no constitutional issues, even the issue of the mandate. I think what we would engage their legal services, DFFE legal services on, will be on like the parliamentary support services support. We'll also engage them on the constitutional mandate of our two departments. And they are very clear, delineated. There's no gray areas on what is environmental protection and what is agricultural production. In fact, our law, Conservation of Agricultural Resources Act, does to a great extent regulate sustainability. But not on environmental issues. So we don't understand why this. And also, the Honorable Chairperson, we want to submit that throughout the process since 2014, we've never had any challenge with them. We consulted them. In fact, they were our main stakeholder when we started the bill throughout the process until lately when we, in fact, this towards the end of the process where we are now, that we received our minister received a letter from the minister DFFE, which looks like perhaps the minister has not yet received it, judging by the communique that was addressed to the chairperson of this August committee. So where we are still surprised as to why this sudden reaction from them. Thank you, Honorable Chairperson and members.
Thank you, Ntate Serache. Honorable members, those are the responses to the follow-up questions of the department. I see two hands coming up. I don't know if it's follow. Mamum Papama.
Thank you, Chair, for the indulgence. You know, some of us are slow thinkers.
It's all right. Go ahead. Go ahead.
Yeah, thank you very much. Chair, you know, I feel that consultation by the department is a challenge that is regularly raised by stakeholders. If you remember, it was also raised in provinces and is also now a concern with the National House of Traditional and Khoi-San leaders. So I would like to know from the department, how do they plan to ensure thorough consultation of all stakeholders, as it does not seem to be clearly outlined in the bill, other than publication of notices in the government gazette and other media? Thank you, Chair.
Thank you, Mamum Papama. The Honorable Kapa.
Thank you, Chair. The silence on my question of legal advice on the Department of Art and Environmental Affairs tells me that they didn't seek this advice. But now the ministers, the Minister of Agriculture and the Minister of Environmental Affairs are going to meet. She is going to meet the minister who is advised, who is legally advised. Therefore, I suggest that she must get freely this advice, because at the moment she doesn't seem to have been made wiser legally towards this issue. Thank you, Chair.
Thank you, Honorable Kapa. Honorable members, that seems to have been comments on part of the issues raised. I think let us wrap up this session, as we still have the A list to revert back to in terms of our agenda of today. But I would like to ensure that legal services engages with the Secretariat in terms of ensuring that we don't have any further delays on their part, and that they are able to send responses to the Secretariat, and that they ought to be circulated amongst members before end of business day on Friday. We will continue processing the bill as we have heard, honorable members, and therefore allow me to invite our legal services to be able to proceed with the A list as we go through clause by clause. I'll now invite Mamu Zenani and the Parliamentary Legal Services to take us through the A list.
Thanks, Chair. May I please ask Mam Kakaza to air the draft that I circulated last week?
Thank you, Chair. Mamuzanan, I gave you co-host powers so that you can share. Thank you.
I will attempt once again, Chair, and if it fails, I'll still ask Mam Kakaza to aid. Thanks, Chair. I don't know if it shows. It does. I don't know if it shows now, Chair.
Yes, we can see it. We may proceed.
Thanks, Chair.
Zanani, you are muted. Zanani, you are muted. We cannot hear you.
Apologies, Chair. Thanks. Chair, what we considered from the inputs that were made was to cover the issue of gazetting or publishing of notices, and we on the paragraphs that were affected would have been paragraph 9, where we inserted other media. That would have been in line 32 on page 9, clause 6. We have inserted other media. Same thing with clause 11. We have also inserted other media, and clause 11 still on page 9. On page 11, line 4, we have inserted other media. Same in clause 12 on line 17 and 32. Same on clause 13 in line 43, and clause 16, line 2, and clause 17, line 25, and clause 21, line 8.
Point of order, Chair. Chair, point of order. Chair, point of order. Metlape. Am I audible?
Yes, you are audible. You can proceed.
Chair, I just feel that maybe the presentation is going too fast for us, and I think I just wanted to really ask that it slow down a little bit in terms of the changes in this new A list. Thanks, Chair.
Thank you, Honorable Masipa. Any further please or input? Mamuzenani. Tate Masipa says we mustn't skim through and fly through the presentation. If you can take us on board close by close. Let us proceed.
My apologies, Chair. I was moving on the assumption that we would just highlight what has changed from the previously presented A list. So what I'm reading through now is the consequential amendment as was proposed in the committee in the last sitting.
Thank you. Any input on the clauses that Mamu Zenani has presented? So we can try and move as slow as we can.
Can we start with the first one, Chair, if you don't mind?
Would you want to make input, Ntate Masipa, as you're saying, let's start with the first one. Is the real input you'd like to make on the first one?
Yes, Chair, thanks.
Thank you.
The first clause, can you go back to it, Mezenani? Because you are on the second in terms of the land definition there.
Would the first clause be the first clause of the A list?
Yeah, the one on definition, on the land definition.
All right, that's fine.
Landowner, sorry, landowner. Okay, just there. So we're talking about a person or community. And I think we did discuss about the juristic persons that have not been included. If legally person include juristic person, fine. But I just wanted to make that point.
Is your question whether this
Mama Muzenani.
My apologies, Chair.
So that we don't have a dialogue between you and Duba or Uma Sipa. This was clarified in our meeting last week in Tate Masipa. So it's either you wanting to pose a different question to that, because you asked the very same question last week and it was answered.
Okay. Chair, I thought it was going to be considered, but thanks, Chair.
No, it was answered in the meeting last week. There was an answer to this. This is why I remember this so well. So it's either you also remember that your question was responded to and there was a real input in terms of what a persons and community means. So it can be that in the next meeting you're asking the same question as if it was not addressed and attended to.
Maybe I did not really, I wasn't too loud, Chair, but I did not agree. But thanks, Chair. I note that I might have not made my objections quite clear. Thanks.
Thank you. Let us proceed. Mama Zenani.
Thanks, Chair. So I understand we're proceeding on clause by clause as we did last week. So I will proceed. Clause 6 would have been in respect of the publication of publishing of the sector plans. So we had said that they shall be published in the Gazette. We have added that the publishing should also be done in other forms of media. So that is the amendment that was inserted. Clause 11, if I may proceed through you, Chair.
Please proceed.
On line clause 11, 943. The clause 11(1) sub 1 says the minister by notice in the Gazette may declare national protected agricultural area the geographic area specified in the notice. So we had said that in the line number 32 we will also include other media. If I may proceed, on subclause 3 as well, in line number on page 11, line number 3, we had also said we will include it's line number 4. In fact, my apologies, Chair. We said we will also include other forms of media. So that is the amendment that we have effected. Clause number 12, consequential as well. In line number 17, we had said we'll also include other media. Same with line number 32. We have also included other media. If I may proceed, clause number 13, in line number 43, the minister or the MEC with the approval of the minister may by notice in the Gazette. We have also made an amendment there to include other media. In clause number 16, in line number 2, it is the same thing as well. We have included the other media. Clause number 17, line number 25, we have inserted the other media. Clause number 20, I am not certain, Chair, if I should go through it again, but it was what we have included in clause number 20 is the amendment that was proposed in clause number 15 about putting in timelines for consideration of agri-ecosystem authorization. So we have included timelines for certain processing of certain application and have deferred other timelines to the regulations for determination in the regulations. So if I may read how the proposed new clause will read, we have inserted subclause A, which will read the competent authority must consider an application for an agro-ecosystem authorization and provide the applicant with a decision in respect of such application within 30 days of receipt of the application or within a reasonable time as may be prescribed for certain specified agro-ecosystem authorizations, and must, in the case of a refusal, provide written reasons for such refusal. That is the new clause that we have inserted. B would then be what used to be 2A, and it shall read, the competent authority must keep and maintain with a written record of all applications submitted for agroecosystem authorizations and the reasons for his or her decisions in respect of such applications. And as indicated, it is an amendment that was proposed in relation to clause number 15.1, 15.2 of the bill. And if I may proceed to clause number 21 is the insertion once again in line number 8 of other media. And as consequential amendment on in line 31 where we've omitted O. Clause number 21, once again, consequential where we've omitted and the full stop and substituted it with O. And after line number 33, we have added the following paragraph. A person who is disqualified from serving as a director of a company in terms of Section 69 of the Companies Act 2008, being Act number 71 of 2008. If I may proceed, Chair, to clause number 26. Clause number 26, from line 14, we've omitted sub 2 and substituted subparagraph 2 and have substituted with the following paragraph: subject to the provisions of the Protection of Personal Information Act of 2013, Act number 4 of 2013, the information of the landowner and land user, and where such landowner or land user is a natural person, the nationality and gender of such landowner or land user. And if I may proceed, Chair, to clause 31, we omitted previous and substituted it with prior in line 55. On clause number 35, Chair, in line 8, after authorizations, we have inserted including reasonable time within which a competent authority may consider and respond to applications for certain specified agroecosystem authorizations. So that addresses the amendment that was proposed in clause 15.2, which was incorporated in clause 20, Chair. This is how our A list looks like for now, Chair. Thank you.
Thank you, Mamu Zenani. Honorable members, any questions, comments, or concerns on the A list presented by the Parliamentary Legal Services? We'll take any questions or comments.
Yeah. Sorry, I'm trying to raise my hand.
No, please go ahead, because I can't see any head or anything because of the presentation. Go ahead.
Chair, thank you very much. Chair, we have had quite a list of other areas that were excluded, that as we discussed last week, those recommendations that were made were agreed to by obviously the department, and we did not really object to them. We just, I think from my side, just want to know why they were not considered or they did not really feature in this. Or maybe the legal advisor can just take us through the areas that they have left out as a result, obviously, then we can be able, obviously, to understand the rationale around those comments that Delrad said they accept. Because, Chair, the reality is that we went through this process to really make sure that we get the inputs from the people, and those inputs that were really making some significant change in the bill, we needed to take them into our A list before we go to the B list. Thanks very much. I just wanted to make sure that we get the rationale and the understanding as to the number of comments that were excluded, that were accepted by Delrad, and we did not also have a problem with them as such. Thanks, Chair.
Thank you, Honorable Ntate Masipa. Any other honorable member that may wish to pose a question or comment? Memasho. Honorable Marshall, I see your hand is up.
Chair, hello?
Yes.
Can you hear me?
Yes, we can hear you, Ma'am Marshall.
Oh, thank you very much. I was saying that, Chair, the A list that was now presented, those amendments that were inserted on the A list as they were going through it, I think they capture most of the things that we were asking them to be included. So to me, I don't think is there any other thing that I think is wrong now. The only thing that one can say is that we are going to be happy if indeed they can include other media when they deal with the issue of communication, as we requested them to insert that. And I think it's being inserted. Thank you very much.
Thank you, Honorable Marshall. Any other input, honorable members? If not, honorable members, perhaps let us ask in terms of processing the legislation and as part of public participation, we as a committee have a duty to consider public inputs and or submissions from stakeholders. In our last meeting, honorable members, our content advisors reminded the committee about some of the inputs from the stakeholders on which the department has already made concessions to. For example, they agreed to the amendments that were not reflected in the draft A list. I have noticed that in the final A list that is proposed, the proposal for notices to be published in other media other than the Gazette has been included in other relevant clauses as proposed by stakeholders and highlighted in the last meeting. However, other proposals are still not included. For my question to the legal team, is there a specific reason why legal services has not included other proposals from stakeholders as highlighted in the last meeting? With the exception of clause 31 subsection 1A, where the majority of members emphasized that the clause should remain as is without giving prior notice, there was no opposition from the committee members to other specific proposals from stakeholders and the concessions from the department. Also, as a reminder, the specific proposals on which the department has made concessions that are still missing on the A list are in respect of clause 15, subsection 4F, and clause 15, subsection 5, in respect of the proposed wording. Clauses 20, subsection 1A, I, and clause 20, subsection 1A, and V in respect of the proposed wording. Again, clause 21 and 22 regarding the consolidation of the clauses, and clause 31, subsection 3 in respect of the proposed wording. If I may get responses on those in particular. Thank you. Namuzenani and the Parliamentary Legal Service team.
Chair, it's
yes, please proceed.
Yes, Chair, we are a bit concerned that there may have been deliberations on certain issues, and it seems now that we have some differences as to whether there were specific resolutions made by the committee in terms of the other amendments. We believe that we had captured what we understood to have been the resolutions of the committee in terms of the amendments. And I'm saying this, Chairperson, as subject to corrections by my colleagues from the State Law Advisor and the Department Legal Advisors. But this is a reflection of what we understood, Chairperson, to have been the resolutions of the committee. And of course, if we missed anything, Chairperson, we are subject to correction. But I would like to invite my colleagues from the State Law Advisor to come in at this stage and just indicate if we had missed anything. That may have been the resolution of the committee at the time. Thank you very much, Chair.
Thank you, Chair. May I speak?
Yes, please proceed, Baufan Breda.
Thank you, Chair. Yes, Chair, I am actually in agreement with my colleague from Parliamentary Legal Services. The initial A-list, Chair, was in fact a reflection of the resolutions made by the committee. Chair, this issue was actually discussed last week when the content advisor raised certain proposals, recommendations that were made by stakeholders during public hearings, and they were discussed during deliberations, and where the department made certain concessions. Chair, however, those were not concessions made by the committee, to our understanding, during the clause-by-clause process. So the initial A-list was a reflection of what the majority of committee members conceded on. So this amended A-list, Chair, is actually the only amendments made to the initial A-list is in respect of consequential amendments, where the committee indicated that there should be publication in other media. So that is why we've made the consequential amendments to those clauses which provide for publication in the Gazette, etc. So that is the only amendments that were reflected. So, Chair, I'm in agreement with my colleague, and we stand to be corrected, but that was our understanding on the concessions made by the committee, that is reflected in the A-list. Thank you, Chair.
Baufan Breda Nkosi, thank you. Honorable members, any further input?
Chair, my hand is up, but you can't see, obviously.
Yes, please go ahead, Dr. Masipa.
Chair, I thank you, and I've listened to the feedback from our legal advice. Chair, I think what we made as obviously submission during the A-list, the previous deliberation, was to make sure that the points that were not acceptable by the department are captured in terms of supporting them. That's really from myself, from our position. We have made several of those recommendations in terms of the clauses that were made by, obviously, the stakeholders. And I will also remind the colleagues that the submissions consisted quite a few of them, but they were basically rejected by most of the members, but we have made those submissions, like the authorization of getting into doing some inspection on the farms and so forth and so on. But the ones that were accepted and noted, we have taken it that the legal advisor understand that these clauses have been accepted as such because they have not been rejected by the members of this portfolio committee. Because if they were rejected by members of this portfolio committee, then we would have obviously deliberated on the rejections of those that department acceded to. But there is a clause 11.2, which was reflected last time when we were in this meeting on that first A list. I think it was reflected. If it was not, apologies. But 11.2b basically is very clear and understood by all of us that the definition of food production will limit other agricultural processes that are taking place on the farm. And we have all indicated that that must obviously be included in the A list, but it's not here on this particular A list. So I'm just making that point clear, Chair. But and you will know that we have made certain added suggestion and they were rejected, like the juristic person. You, the legal advisor, said no, the person covered the juristic person. We have said we feel that an additional, that clause can change, to reflect a juristic person, trusts and other legal entities as such. But I think it is very important, Chair, that the submission when the A list is being put together is considered all the inputs that were accepted by the Department of Agriculture that came before us to say that we are okay with this particular, and we did not object to those items that the department said we are okay. If we objected them, then I would understand the argument from the legal advisors that, you know what, you as members, you have objected. So that's really my plea, sir. Thank you.
Thank you, Honorable Ntate Masipa. Honorable members, any further input? If not, honorable members, let me take the opportunity in pointing out that processing of legislation is always a continuous process. The committee does not always repeat itself in terms of discussions that have been held and relies on legal services to use its prerogative where there are no conflicting issues. For example, the committee did not deliberate on notices, but we have been able to include it, but not others. In this regard, honorable members, perhaps let us find out from members whether the committee members are opposed to the amendments or comfortable with the above inputs or amendments not being included in the PDAL bill, despite the department agreeing to them. Otherwise, as they are straightforward amendments that seek to strengthen or simplify the bill, legal services should effect the necessary changes and return the final A list to the Portfolio Committee on Agriculture, Land Reform and Rural Development no later than Wednesday, the 22nd of November, 2023, that being tomorrow. Can I get input from yourselves, honorable members?
Chair, I
Yes,
think
Ntate Masipa.
colleagues might want to raise a hand if they did not up first. I think I might have missed some of the parts, but I captured what you indicated, that obviously we request that we get an updated, obviously, list by tomorrow close of business. I am fully in support.
Thank you, Ntate Masipa. Any further input, honorable members? You may come in as you have input, because I don't see any hands on participants. Going once, going twice. Thank you, honorable members. If no further input, we will then request the final A list to be sent by legal services. Mamuzenan.
My apologies, Chair. Thanks. My colleague would like to make an input.
All right. Please go ahead.
Thank you very much, Chair. In view of what has just been said, Chairperson, may I ask that as you close your meeting, that the Office of the State Law Advisor, the Committee Secretariat, and us just remain for a few minutes after that, just to have a discussion on how we proceed, so that we can be able to meet your deadline of tomorrow.
Thank you. That is
if
in
you will
order.
allow that, Chair. Yes.
Yes, that is in order. You may remain. Perhaps you may, in your engagement, take note of the landowner definition in terms of persons, and revert back to us if utilizing touristic person is of major difference. You will look into that as well. I think that was the only thing I missed out in terms of what I wanted to raise. But we will await, therefore, the consideration of the final A list. Honorable members, that brings us to the end of our deliberations. We have 3 outstanding minutes that I would like with the remaining time to utilize, so that we can be able to adopt those minutes. Allow me to request the Secretariat to flight the minutes so we can dispense of that, and we can leave the legal team to be able to proceed with their plans in drafting the final A list. Amukakaza. There we go, honorable members. The minutes of the 3rd of November, 2023. Page 1. Page 2. Thank you, honorable members. Can we have a mover for the adoption of the minutes of the 3rd of November, 2023? Any mover for the adoption, honorable members? Am I the only person on the platform? Am I still audible?
I would be,
you're
Chair,
audible,
but
Chair.
unfortunately, I wasn't part of the meeting.
Chair,
Yes, can we have a mover for
yes,
the
I think
adoption of the minutes?
Honorable Matlo is moving for the adoption of the minutes.
Thank you, Honorable Mahlo moves for the adoption of the minutes of the 3rd of November 2023. Can we have a second, honorable members?
Yes, Chair. I, Ndumiso Tapa, second the move for the adoption of the minutes of the.
Thank you, Honorable Tapa. Seconds the adoption of the minutes. Honorable members, any matters arising? Page 1. Page 2. Still on matters arising. Page 2. With no matters arising, honorable members, the minutes of the 3rd of November 2023 have been duly adopted. Can we move on to the next set of minutes? Our next set of minutes, honorable members, is the 7th of November 2023. Page 1. Page 2. Page 3.
Just a clarity on page 2, Chair.
Yes, Honorable Tapa.
Paragraph 231. Just a clarity there, that is it in order that as members of the committee, a member can, as Honorable Masipa raised there, a view of the members of the DA? Or is it the member can raise a view as a member, or is it correct that a member raises the statement in collective as for the members of that party? Just for clarity, Chair.
It is minutes, Honorable Kapa, of the committee, and Honorable Masipa did table a statement. So I don't know how you would want us to capture that in minutes, because it was indeed Honorable Masipa.
Let me read some matters arising.
All right. Thank you. I take it it's minutes, so we must capture the minutes as a true reflection of the meeting. On page 3, honorable members. Thank you, honorable members. Can we have a mover for the adoption of the minutes of the 7th of November 2023?
I, Thandeka Mulukom Papama, would like to move for the adoption of the minutes of the 7th of November 2023. Thank you very much, Chair.
Raleboga Memoloko for moving for the adoption of the minutes of the 7th of November 2023. Honorable members, can we have a seconder?
I, Mr. Tapa, second the move for the adoption of the minutes of the 7th of November to be correct record. I thank you, Chair.
Thank you, Honorable Tapa. Seconds, Memoloko, for the adoption of the minutes of the 7th of November 2023 as a true reflection of the meeting we held. Any matters arising, honorable members? Page 1. page 2.
My issue was on page 2, Chair, page 231.
Yes.
Yes.
Go ahead, Honorable Kabo.
For the purpose of record, I was asking Chair for clarity whether this is the correct process in order that a member of the committee, when raising a view, can say they are raising this issue on behalf of the other members of his or her party. Is that in order? Just a clarity, Chair.
Thank you, Honorable Kapa. I do believe that when Honorable Masipa tabled the statement, he did say that it is the view of himself and party members. I stand to be corrected. Honorable Masipa, can you clarify that? Was it just your view, or it was a
Chair, may I
focus?
come in?
Yes,
May
you may
I come in,
in.
Chair?
You may.
Honorable Masipa and I had discussed this, and it is a view of him and myself as DA party members sitting on the committee. Thank you.
Thank you, Mamum Babama, for the clarity. Honorable Kapa, that's the clarity. It is a party position, so he was not only speaking for himself, but on that of the party members in the committee.
Chair, I have my hands up.
Oh, yes, Memato. Sorry, honorable members, because we have the minutes flighted, I'm not able to see the hands, so please feel free to interject. Honorable Marshall, you may proceed.
Thank you, Chair. You see, Chair, I understand that what is the concern of Ntate Kapa on point 231. I don't remember in any of our minutes coming from, since we were there in this committee, where party members, they stayed as party members. I was thinking that when we are in parliament, both of us coming from different parties, but once we are in a committee of parliament, we are a committee of parliament, not segregating coming from each party and whatever, because I don't have any part of the minutes where a member of a party will say, as African National Congress, this is what we said. I have never seen that, but this is for the first time I see it. I definitely feel also like in Ntate Kapa that it seems like as if now we are starting to work in silos, like as individual parties in the minutes of the Parliament Committee. I think this must be taken back to the legal advisors of Parliament to advise us, because here we are talking about the minutes of a committee of Parliament, not as individuals, parties. I don't know, but I'm subjected to corrections. But that was my understanding, that when we are in that committee, we are like bana ba motho, a re tšerele maphaga. Mara bjale a ke tsebe le tla no re tlhalosetša ba ile reng o ya ka molao le dikwešiša go feta rena ba bangwe re thušeng re kgone go ba clear. Thank you.
In assisting Honorable Marshall, we don't even need to revert back to legal services. We have our secretariat here who can speak on procedure. Manyamza, welcome and thank you for joining the meeting. Members have a concern and the matters arising on 2.3.1 having been captured correctly in terms of the Honorable Mamum Babama saying it's a party position. Mamunyamza. Ukona? KK. Mamukakaza.
Hello, Chair. I think Uma Munyamza has raised her hands, Chair. I think she wants to respond to this.
Yeah, but she's not speaking. Can you enable her to speak? Maybe she needs, the only hand I see here is Honorable Mpapama, and I think it is a legacy hand. I stand to be corrected. Manyamza, go ahead.
It's a new hand.
But from my side, Chair, if I can just add to what Mamu Papama is saying, this is the reflection of what has transpired in the meeting that took place that day. And I was not part of that meeting, Chair, unfortunately. But according to the minutes, you have to reflect what was discussed in that meeting. So if that statement was said at that time, that's correct that Mamu Nyamza is captured as it is in this meeting, in these minutes. Thank you, Chair.
Thank you. That is my understanding, honorable members, as I did say, these are minutes of the committee, and this is what transpired in the meeting. And therefore, it is correctly captured. And Honorable Mpapama has re-emphasized that now it is not Honorable Masipa's views, but it is that of the DA members in the committee.
May I come in, Chair?
Yes,
May I come in, Chair?
Mpankoma, please do.
I feel that these concerns should have been raised at the time that Honorable Masipa was making the statement. Now it is too late. It's reflected in the minutes. We cannot change the minutes anyway. Thank you.
Thank you, Mpankoma. I think we are clear on that. There is no one or any utterances that have come saying the minutes must be changed. Minutes have been adopted and we are looking at matters arising. And therefore, I think members raised their issues of concern, but you have reassured us that this is the position of the party and that is settled. Honorable members, any other matters arising?
Can I come last on this one, Chair? Thank you very much for this clarity. It was not hearing the recording of the minutes. It was just a clarity on the issue. The members have clarified that they have caucused on this before bringing it to the committee, and therefore it is one of those things. If Mr. Honorable Masipa would have heard me saying this and saying Honorable Chete had said this to me, he would have said, no, this is a static group issue. I thank you for this clarity. I understand now that it is in order to do this thing. Thank you very much.
Thank you, Honorable Kapa. Honorable members, we still on matters arising, page 3. Page 3. If no further matters arising, honorable members, the minutes of the 7th of November 2023 have been duly adopted. Thank you. Can we move to our last set of minutes? The minutes of the 14th of November 2023, page 1. Page 2. Page 3. Page 4. Thank you, honorable members. Can we have a mover for the adoption of the minutes of the 14th of November, 2023?
Chair,
Any mover? Go ahead, Mematlo.
Thank you very much. Chair, I, Patricia Matho, stand to move for the adoption of the minutes of the 14th of November 2023. Thank you, as a true reflection of what happened.
Thank you, Mematlo. Moves for the adoption of the minutes of the 14th of November 2023. And we have a second, honorable members.
Can I come in, Chair?
Yes, Honorable Kapa.
I, Ndumiso Kapa, second the move for the adoption of the minutes of to be the correct record. I think.
Thank you, Honorable Kapa. Seconds the adoption of the minutes of the 14th of November 2023. Any matters arising, honorable members? Page 1. Page 2. Page 3. Page 4. Thank you, honorable members. With no matters arising, the minutes of the 14th of November 2023 have been duly adopted. That is all on our program of the day, honorable members. Allow me to take this opportunity to thank all the honorable members for having attended the Portfolio Committee meeting on Agricultural Land Reform and Rural Development. And also take this opportunity to thank the executive, Mahmoud Didiza and Ubao Skwacha, for their attendance, as well as the officials of the department, as led by the DDG Ndadeserache. Allow me to thank our parliamentary legal services and state law advisor for their attendance and their input in processing of the A-list of the Preservation and Development of Agricultural Land Bill. Honorable members, let me take this opportunity in thanking all those that took time to join our meeting, and also thank the respected members of the media who may or may not have been on the platform. Allow me to thank our enablers, the staff, our secretariat, content advisors, the researchers, as well as the logistics team and the IT team for having ensured that we've been able to have yet again a successful hybrid meeting. Honorable members, let me remind you that there is plenary this afternoon at 2 o'clock in the Parliament, Good Hope Chamber, and we request you to be at the house already seated at 2 o'clock. For those that will be joining on virtually, please ensure that you have logged on timelessly. Honorable members, thank you. Have a great week ahead, and we'll see you in the corridors of Parliament or in the virtual platforms. Thank you. Bye.
Bye,
you.
bye, Chair.
Bye-bye.
Thank you, Chair.
Thank you. We shall leave the legal team as they continue on their engagements. Thank you.
Recording stopped.